Everyone, welcome to Code of Civil Procedure lectures. In this video, we will discuss preliminary under Part 1 of Civil Procedure Code. Code of Civil Procedure is a procedural or adjective law. Law can be divided into two groups, that is, procedural law and substantive law. Some of you may have doubts regarding the concept of substantive law and procedural law. So, let me clarify them for you. Substantive law determines rights and the liabilities of the citizens, while procedural law prescribes procedures for the enforcement of those rights and the liabilities determined by the rules of substantive law. To say in other words, the function of substantive law is to create or define rights or legal status and to define the nature and extent of legal duties, while procedural law provides the machinery or the manner in which the legal rights or status or legal duties may be enforced or recognized by a court of law to deliver justice. So procedural law neither creates nor takes away any right but only helps to implement or administer substantive laws. Let me give you some examples of substantive law and the procedural law. The Indian Penal Code of 1860, the Indian Contract Act, Transfer of Property Act, Negotiable Instruments Act, Industrial Disputes Act are substantive laws, while Code of Civil Procedure, the Limitation Act, Indian Evidence Act, the Code of Criminal Procedure are the instances of procedural law. Procedural law governs the process of litigation, so the efficacy of substantive laws to a large extent depends upon the quality of procedural laws. Unless the procedure is simple, expeditious, and inexpensive, substantive laws, howsoever good, are bound to fail in achieving their object and reaching the goal. Section 1 of the Code provides short title, commencement, and extent. It is titled as Code of Civil Procedure 1908, commonly called Civil Procedure Code. It was enacted by Imperial Legislative Council on the 21st March 1908. It came into force on the 1st of January 1909. Extent and applicability of the Code. It extends to the whole of India except the state of Nagaland and the tribal areas. The Act did not extend to the state of Jammu and Kashmir until Jammu and Kashmir Reorganization Act of 2019 came into force on the 31st of October in the same year, and the erstwhile state was reorganized into Union Territories of Jammu and Kashmir and Ladakh. Now, all the central laws, including Civil Procedure Code, which are applicable to other parts of the country, are now applicable to Jammu and Kashmir from October 31st, 2019. Scope of the Code. The Code is exhaustive on matters specifically dealt with by it. However, it is not exhaustive on the points not specifically dealt with therein. For instance, when there arises a new circumstances in the future litigation, and the Code does not provide procedure for such situation, the Court has the inherent power to meet such circumstances and deal with the matter according to the principles of natural justice, equity, and good conscience. The code specifically provides under Section 151 that nothing in this code shall be deemed to limit or otherwise affect the inherent power of the court to make such orders as may be necessary for the ends of justice or to prevent abuse of the process of the court. Objective of the code. The preamble of the code states that the object of the code is to consolidate and amend the laws relating to the procedure of the courts of civil judicature. To consolidate means to collect, to gather. So, Civil Procedure Code is a consolidated code collecting all the laws relating to the procedure to be adopted by the civil code. It is designed to facilitate justice and further its ends, and is not a penal enactment for punishment and penalties. The Supreme Court, in the case of Syed Muhammad Bakr versus Abdul Habib Hassan, stated that a procedural law is always in aid of justice, not in contravention or to defeat the very object which is sought to be achieved. Procedural law neither creates nor takes away any right. Rather, it puts life into substantive law by providing a remedy and implement the well-known maxim ubi iusi be remedium. So the Court of Civil Procedure carries with itself the essence of the civil procedural rights of the citizens to approach the court when our civil rights are violated. It enables us to claim our right and the cause of action expediently, and with best efforts till the ends of suit to meet the ends of justice. Composition of the code. The code is divided into two parts. The first part contains 158 sections and the second part contains the first schedule, which has 51 orders and rules. The body of the code containing sections is fundamental and cannot be amended except by the legislature, while the first schedule of the code containing orders and rules can be amended by the high courts. The sections and the rules must be read together and harmoniously construed. But if rules are inconsistent with the sections, the latter will prevail. Appendices contains model forms of pleadings, processes, decrees, appeals, execution procedure, etc. Section 2 of the code, which provides definition clause, is also a part of preliminary under part 1 of the code, but we will study them in the next lectures on the Code of Civil Procedures. Thank you for watching this video.